Thanks so much for joining us today. Welcome to our November Deep Dive webinar. Some people are populating in and connecting to audio right now, but we're going to go ahead and get started. Today, we're going to cover the jurisdictional opt-out results from Tuesday's election night, and then we're going to cover the third and final round of draft psilocybin rules released by the OHA. We previously covered the second round of draft rules back in early September. So today our main focus is to kind of hit the most important rules and point out the OHA's most important changes in the rules. Overall, we think the rules have been changed in pretty substantially positive ways from the September draft. There's still a lot of room for improvement, but by and large, I think we're moving forward in a positive direction. We do have a lot of people from the Oregon DOJ and OHA who are attending the webinar today, and many others in the Oregon psilocybin space. So please don't call people out on the phone specifically other than Emerge's speakers. And speaking with you all today from Emerge is Dave Kopilak. He is a business lawyer and primary drafter of Measure 109. We have Sean Clancy, who's an IP and business attorney. He was also on the Measure 109 drafting team. We have Alex Berger, who's regulatory and compliance lawyer and land use attorney. Myself, I'm a business lawyer. I was also on the Measure 109 drafting team. And then Corinne Selko from our firm is on standby. She's a land use attorney, and she might pop in to answer some questions or provide some context as needed. So as usual, we're going to spend 30 or 45 minutes speaking, and then the remainder of the 2-hour event will be dedicated to a lively discussion. We're recording this event. We tend to post the speaker presentation portion to our YouTube channel, but we won't have any audio or video from the Q&A session, so you don't have to worry about your face or voice showing up online. We do, as always, want this event to be conversational in nature. We'd like for it to be a safe space to discuss the Psilocybin Services Act or any other related ideas. So we just ask that you please remain open to all viewpoints expressed today and be respectful of others. And to keep everything streamlined, when you have questions or comments, please just state that you have a question or comment in the chat box, or if your question or comment is really concise, you can just type it out. You can also raise your hand using the reactions button, and I can place you into a queue of questions. And I'm going to monitor the chat box throughout the event and call on people to speak during the Q&A session, which will occur after our speakers present today. And when you're asking questions, please just try to avoid asking us fact-specific questions. We're not acting as your attorneys or giving you any legal advice today. We're merely providing information for general educational purposes only. And if we don't get to your questions or comments today, feel free to email us at capitalm109@emergelawgroup.com. I'm going to put that email address in the chat box in a little bit. And sadly, we're coming to the end of the year. Our final webinar of 2022 will likely be in early to mid-December from 4 to 6 p.m. Pacific time. We're probably going to discuss financing and capital raising, but just check out our website or social media pages over the next few weeks for that upcoming information. And Dave is going to kick us off by covering Tuesday's election night results.
Okay, hey everybody. So I'm sure most of you are familiar with some of the election results. There was over 100 local jurisdictions, both counties and cities, that had opt-out ordinances on. I had the pleasure of hanging out on the Oregon Secretary of State's website for about 2 hours yesterday, going through every city and every county and making sure we had everything. And we've put together, this is the latest version that you're seeing of our opt-out map. Green means that the particular jurisdiction is, there's no opt-out, that psilocybin businesses are permitted. And red means they're not. And so you can see that there's certain counties where, certain red counties where they might have a little green circle in there. That means that the unincorporated county is out, but there's safe haven cities that are within the county. And then conversely, you see there's some green counties that have red circles. And so the unincorporated county there is in, and but certain cities within the county have opted out. Of the more than 100 ordinances that were on the ballot, a grand total of 4 rejected the opt-out. So the batting average wasn't too good there, but I think there were some major victories in Deschutes County and Jackson County. Those were the only jurisdictions I was aware of that had formal campaigns against the opt-out ordinance. So my hat is off to the folks who ran those campaigns and the folks who will benefit from there not being an opt-out. The other two places where the opt-out was rejected was Phoenix, the city of Phoenix in Jackson County, yay Phoenix. And my favorite was the city of Wheeler in Tillamook County, where the opt-out was rejected by one single vote. The vote was 92 to 91, and somebody cast a deciding vote, and Wheeler is in. So that was great. You know, this is not the end of the game, of course. Our land use colleague Corinne has been looking for several clients, speaking with planning commissioners, and just because a particular jurisdiction has not opted out doesn't mean every single property is good to go. There's a land use analysis to be done for every property, and there's TPM, time, place, manner restrictions that are coming down the pike. And so even in Jackson County and Deschutes County, where the vote was uncertain, those folks, I guess to their credit, have already engaged before Election Day in thinking about TPM regulations in the event the opt-out was rejected, and now it has been rejected. So they're all in on that. So oh, and there you go. Thanks, Sean, for posting the map in the link. But anyway, that's it. You know, we know what we're doing, or we know where we stand in that regard. So we were rooting for Jackson County and Deschutes County. Those were again the big ones. I think there weren't many other surprises or letdowns. We kind of knew how most things would go. I guess the exception is my home county of Clackamas County. I couldn't believe it. Clackamas County, the vote was pretty bad, and Clackamas County adopted the opt-out. And strangely enough, I think we have 13 cities in Clackamas County that didn't even put a measure on. So strange events in Clackamas County where the county's out, but almost all the cities are in. So I don't understand how that vote went, but that's the way it goes. So any questions on opt-outs or specific jurisdictions, we can answer them. But again, that's just step one, and we usually refer folks to Corinne for any particular property. So that's it for the opt-outs, unless somebody has questions. Kaci, do you want to take questions at the end on everything? Okay. So Sean, I think Sean's going to talk next, and now we're going to start going through the rules a little bit. We're going to take turns going through the rules. We'll try to hit the highlights and then open it up for Q&A. So go ahead, Sean, you're going to talk about products.
Yeah, thanks, Dave. Apologies in advance. I've been really sick after traveling for a business conference, so my voice is not the best. I might go off camera. But yeah, I was privileged to be part of the Oregon Health Authority's September Rules Advisory Committee, or the RAC, regarding these rules for products, labeling, and transportation. So I was going to cover some of the highlights from the outcomes of that RAC, identifying key changes. And so one of the most important ones is a new definition that now appears throughout the rules, and that's the definition of psilocybin analyte. This is a new definition that previously didn't exist in the rules and didn't exist in the statute. It's based on a recommendation that the Oregon Health Authority adopted to create a separate definition for psilocybin by itself, separate from psilocin. And this seems kind of technical, but basically the statute defines psilocybin as both psilocybin and psilocin. Those are two different compounds, though. Psilocybin is metabolized to psilocin in the body. They both have an effect, but they're different compounds. So without this new definition, what would have been happening is that every licensee would be looking at twice the amount of testing and labeling requirements, because they'd be testing for two different compounds, both psilocybin and psilocin, testing and labeling for both of them. There's all kinds of other ambiguities that might have appeared because the word was there by itself. Could have been interpreted to mean one or the other, or both. Or to things about maximum dosage amounts, serving sizes, etc. So now there's this word psilocybin analyte, and so psilocybin analyte now appears to solve that problem. And so it's all over the rules, and that's the word that's to just mean psilocybin by itself, not psilocybin and psilocin. So hopefully saved a lot of headaches there. Thanks to Oregon Health Authority for hearing that one, and hopefully save a bunch of headaches. Rule 2015 regarding allowable species. So as most people probably know, there's still just the one species requirement, psilocybin cubensis. this rule was clarified in some ways to make it clear that that single species is only allowed on the licensed premises of manufacturers. But by clarifying that the allowable species is what's the limit on the licensed premises. So there was a clarification to Rule 2015 that makes it clearer, where it was not quite clear before, that outside the parameters of the licensed premises, you could have other types of mushrooms. So it opens up the possibility then of, we've got, say, a culinary mushroom facility down the hall by a different entity on a different premises, separate from the licensed premises owned by the licensee. There's a related rule, number 4300, also addressing requirements for licensed premises. And that one gives an example, sort of corroborating this, that a manufacturer with an edible psilocybin production endorsement cannot process food intended for commercial sale on the licensed premises, sort of implying that off the licensed premises, those things, edible mushrooms, could be manufactured. So you could have a single building where you've got the licensee and the licensed premises in one portion, and then separately you've got a different entity, a neighboring entity that could be, manufacturing your culinary mushrooms, doing the shiitakes, lobster mushrooms, and chanterelles. So previously that was maybe not allowed, which would have been very restrictive, and so now this makes it clear that that's a possibility. Rule 2310 regarding packaging and serving sizes. This is one that didn't change. I was sort of disappointed by that. Rule 2310 says that 25 milligrams of psilocybin analyte is now the maximum serving, and there's only one serving per package. So that means that every single serving of psilocybin will be in a single package. This is going to create a lot of packaging. There's going to be a lot of garbage. There's going to be a lot of labor costs and material costs. It's understandable. Oregon Health Authority's concern here is preventing somebody from accidentally ingesting a higher dose than expected. So they've chosen to limit to 25 milligrams per serving, which is consistent with what would produce a psychedelic effect in most people. And it's also the amount used in most clinical trials. But they are still limiting it to one serving per package. So that's a rule that did not change. The topic of on-premises food came up a number of times in the product subcommittee, and we talked about Rule 5170 related to the sale and transfer of psilocybin products. That rule was unchanged. There it specifies that clients can only mix psilocybin products. So when they're taking psilocybin products, mix them with packaged food or beverages before consuming, as long as those were unopened. So people are limited to unopened packaged food or beverages to mix psilocybin products with. There's that rule, that word's not defined mix, then it specifically says that homemade food and beverages, dietary nutritional supplements, prescription, non-prescription drugs cannot be mixed with psilocybin products. So this created some concern that, a psilocybin administration session can theoretically last several hours. And so people get hungry during that time. And so, somebody has diabetes or some special dietary restrictions or limited budget for packaged food. All these things were concerns for whether or not people would be restricted from just bringing some food along. And so Oregon Health Authority heard that concern. They didn't actually address it in this rule. But in a different rule, 4480, regarding service center privileges and prohibition, section 7, they did specifically add a portion to say that service centers may permit clients to bring any food item and non-alcoholic beverage into the licensed premises for consumption. So that was a good change to clarify that people will be able to have food. I guess no Pinot Noir or anything like that. It's got to be non-alcoholic beverages, but at least people can bring food from off premises. It doesn't have to be and it doesn't have to be prepackaged. There was another rule that came up, and I guess it was related to transportation, or it was part of our subcommittee, Rule 5160. It was regarding cancellation policies, and it was required that facilitators offer a full refund to any client canceling 24 hours or more before their scheduled session. That type of timeline for anybody who's worked in client services, and especially for scheduling something like a session that could last several hours poses a real scheduling challenge, especially if you have people canceling only 24 hours in advance. It's almost impossible to find a replacement for that time slot. If you talk about how group sessions would be involved, it even kind of magnifies the potential headaches that would cause for facilitators and service centers scheduling these sessions. So fortunately, the Oregon Health Authority has removed that required cancellation policy. And the latest revision just says facilitators have to list their fees, but it doesn't say anything requiring them to have some sort of 24-hour cancellation policy. There is still a vestigial piece in the client bill of rights in point 27 mentioning the 24-hour cancellation policy, so hopefully they can catch that in the final during the comment section here. But I think it's good. It'll be good for service centers and clients that's no longer in the rules. Rule 5170 that previously required that the transfer and consumption of psilocybin products occur indoors. So that meant that the consumption and transfer had to only occur.
Sean, it looks like we lost you. Let's just give him 30 seconds or a minute to bounce back.
Considerations for how a service center determine where the consumption and transfer take place. But that's nice that it's no longer the Oregon Health Authority dictating that. Now it'll be up to the facilities to make their own use their business judgment, and potentially allow those things to happen outdoors so that people can consume and consume psilocybin products outside. Rule 6110 was another rule that I'm glad to see have changed. That rule was previously really limiting for psilocybin businesses. It covered advertising and advertising online, including outlets that might include apps like Google Maps and location-based devices like cellular phones. So obviously in this day and age, you can imagine how utterly impossible it might be for a service center or in a remote location or even in an urban area to be restricted from comfortably advertising in those outlets and getting people to even just find where they exist. Virtually everyone uses their phone and a Maps app to find everything these days. So this rule was a pretty hot topic in the RAC, and I'm very pleased the final updated language is ultimately still requires the licensees make reasonable efforts to prevent people under 21 from seeing their advertising. But I think it strikes a nice balance there. So making some efforts to prevent targeting minors, but not completely strangling service centers' ability to identify where they exist on location-based devices. Rule 8200, this was another one that was discussed in the RAC a little bit regarding product tracking. This rule was not changed. I was an advocate for allowing a more open system. Anybody familiar with cannabis will know how frustrating the Metric product tracking system can be. Metric is a proprietary software vendor that has basically an exclusive contract with the state of Oregon for all the seed to sale tracking of cannabis products. Ultimately, the Psilocybin Services program will have a similar vendor, and that will be tracking the products throughout. In order to interact with this software vendor, the vendor needs to give permission. And so we were hoping that permission might be a little more lenient, that there might be a little more room for other third-party apps to interact with it without needing such permission, because the result can be essentially a software monopoly. We'll see what the software environment becomes as the system rolls out, but hopefully there'll be enough workable options and some competition so that people aren't stuck doing one of the most important aspects of the system, the tracking of the products throughout it. Hopefully they'll have some viable options that can compete and interact with the system, and that there's a reasonable number of choices for people, and they don't get frustrated and hung up and even potentially experience regulatory violations because of software issues. So hopefully that's not as big of a problem, but I was a little disappointed that change didn't go through. Rule 8220 regarding unique identification numbers. This rule limits how psilocybin products of different types can be mixed. This rule was not changed also. I read this rule as preventing mixing of assorted mushrooms of different sizes from different harvest lots. So the mushrooms are segregated into different harvest lots during the harvest process. And this rule would seem, unless they're the same size from mixing them, the same size and potency and type, unless those things are all the same, they wouldn't be able to mix. So, I mean, essentially, this was kind of a common theme in a lot of the product rules, is that because whole mushrooms are going to be variable, there's going to be a wide variety of, caps and stems and different sizes and things. That creates a lack of uniformity, and the system is hoping for uniformity. And so, it will be a challenge for manufacturers that want to continue to provide whole mushroom natural form psilocybin products. And so this was just another kind of example of that will sort of reward people for people will be more incentivized to process psilocybin or make it homogenized. So I think this is going to increase labor costs and limit some flexibility to combine harvest lots of whole mushrooms. With that though, I think overall the products rules have definitely improved. It would be nice if there was more sympathy for people trying to do whole mushroom products. They're already going to have some challenges in terms of having to somehow consistently test their whole mushrooms. But overall, I think the rules have improved a lot. So with that, I'm turning it over to Alex.
Thanks, Sean. So I'm going to discuss some of the changes to the licensing rules specifically, and I'm just going to dive right in here. So first, everybody's favorite topic, fees. I thought when the original draft rules came out that the fees were relatively high for the annual licensing fees. OHA did not make any changes. So the fees are still going to be $10,000 a year for a manufacturer, service center, or lab license, and then $2,000 a year for a facilitator license, which are significantly higher than cannabis license fees. And I thought maybe the OHA would take another look at that, but they did not. One positive change to the licensing rules, I think, is that the OHA proposed to change the definition of an applicant. An applicant is basically means that your name is on the license, an applicant's name is on the license, and you are jointly and severally liable and responsible for that license and has certain disclosure requirements. So initially, OHA had defined an applicant as any person or entity that owns 10% of the licensed business, and they went ahead and increased that threshold to 20% interest in the ownership interest in the license, or entitlement to 20% of profits or revenue, as opposed to that initial 10% threshold. And that's good because fewer folks will have to undergo fingerprinting and will have to be approved for the license at the application phase. In terms of existing licensees, OHA is also proposing to make it easier to add or remove applicants to the existing license. So previously, OHA was requiring that new applicants get written permission before they are added to the license. But OHA has proposed to change that rule so that you merely have to notify OHA within 10 business days of adding or removing an applicant. And then if OHA, after that notification, if OHA determines that the applicant would be unlicensable, the licensee then has 30 days to remove that applicant. So again, that is going to streamline things for licensees who are looking to add large equity owners or change the management of their licenses. One thing I thought was a little confusing, though, is in Rule 4200 sub 3, OHA seems to be requiring a $250 change fee payment prior to adding a new applicant. So that seems to be at odds with the ability to just add an applicant and notify OHA after the fact. I'm not sure if that was just a typo, but it does seem to be at odds with that rule. OHA also made some changes to their financial interest rules. A financial interest holder is basically any owner of the licensed business who does not rise to the level of applicant. And previously, OHA was proposing that an applicant for a license would have to disclose every single financial interest holder and notify OHA if after licensure they wanted to add a financial interest holder. OHA has done away with that, is no longer requiring that you disclose any financial interest holders, and is only proposing to require applicants to maintain an internal list of financial interest holders and provide that list to OHA within 15 days of request. So again, that's really streamlining the application process and allowing licensees to add more capital and more financial interest holders without having to notify OHA or get pre-approval from OHA. So those were the big changes, most of which were good, I think, in the licensing space. And now I'm going to kick it over to Kaci to talk about preparation sessions.
Thanks, Alex. Okay, I'm going to fly through this a little bit. I'm really just going to cover the most important rules and then point out some of the changes since the last round of rules. So talking about preparation sessions, a facilitator has to complete a preparation session with a client at least 24 hours before the client's first administration session. But after that initial preparation session, there's no additional preparation sessions required with that client for 12 months. There is a new rule governing preparation sessions, and that's just that facilitators have to provide an opportunity to discuss internal and external factors that could impact a client's experience. So that includes things like intentions and expectations. It also includes things like allergies and sun exposure sensitivity if the client's going to be outdoors. There's also a really large volume of documents that have to be provided to the client and reviewed either during one or more preparation sessions or at least before an administration session occurs. So there's a client information form with 2 categories of questions that has to be completed before an administration session. And the first category of questions really just requires the client to answer yes or no to a list of questions. There's one new question added by the OHA in this category, which is whether the client wants to share any conditions, sensitivities, or health concerns with the facilitator. And if the client responds yes, then the facilitator has to work with the client to create a written plan describing reasonable steps that the facilitator will take to accommodate those conditions. And then there's also, well, before I move on, if the facilitator reviews those yes or no questions, they have to determine if the client qualifies for psilocybin services. It's kind of a red light, yellow light system, and the OHA rules actually instruct facilitators what to do based on the client's response. And then there's a second category of questions, which are optional narrative questions that a client has discretion to answer. There's also a transportation plan that has to be completed before an administration session, which Alex, I think, will discuss later when he details administration sessions. And then there's a client safety plan that has to be completed before an administration session. This was previously an optional document, but now it's mandated. It has to identify risks and challenges specific to a client's circumstances and the resources available to the client to mitigate those risks and challenges. And then there's a whole set of documents that have to be provided to the client and reviewed during the preparation session. and that includes an informed consent. That informed consent hasn't changed much. It's just a document where the client's initialing next to a laundry list of items, such as the fact that psilocybin's not a medical treatment and it's a controlled substance and things like that. Then there's also a Bill of Rights, which also includes a laundry list of rights that a client has, which are obligations for facilitators and service centers regarding the treatment and protection of clients. Those have to be posted in a prominent area in a service center, and there could be repercussions for facilitators and service centers who violate the Bill of Rights. There's a product information document, which identifies a ton of information about all of the psilocybin products that might be available to be consumed during an administration session. There needs to be a documentation of fees document that needs to indicate the allocation of fees paid to the facilitators versus the service centers. It also has to include refund policies and cancellation fees. There's a service center emergency plan. Service centers have to provide this document to facilitators offering services at the service center before the facilitator provides any services at the location. This is a new requirement. It's also a new requirement that the facilitator has to provide that document to a client at the preparation session. And then there's a disclosure form for de-identified client data. This is a new requirement. If a facilitator or service center intends to share a client's de-identified data, then the facilitator or service center has to get a disclosure form from the client during the preparation session. And that form is pre-mandated by the OHA. It's housed on their website or will be housed on the website. And then there's a variety of written consents for certain things that have to be obtained at a preparation session. And that includes things like participation in a group administration session, use of supportive touch by a facilitator, participating in a training practicum, video and audio recording of an administration session, the presence of an interpreter or a client support person, the use of different facilitators for different sessions. And then there's two new consent requirements. The consumption of a secondary dose of products during an administration session needs to be consented to in advance. And then also participation in an administration session where the licensed representative of the service center is present during the administration session. And under the rules, service centers have to have one licensed representative present at the service center while a facilitator is facilitating an administration session. So that's it for prep sessions. I'll kick it back over to Alex for administration sessions.
Thanks, Kaci. So I'm going to talk a little bit about the proposed rules for administration sessions. These are the sessions where the service center provides the psilocybin to the client, and then the facilitator facilitates with the client the administration of the product and then the effects. So the rules allow for group administration sessions, and the latest revisions to the rules have increased the client to facilitator ratio during a group administration session. And that ratio is based on the maximum dose that will be consumed at the session. So if the maximum dose is 5 milligrams, the facilitator to client ratio is 1 facilitator to 25 clients. And that increased from the previous rules that the ratio was 1 to 16. So that is good for microdosing, for example, because you won't need as many facilitators at a group administration session for smaller doses. And then, generally there will be larger group sessions with fewer facilitators, which is going to be good from a cost perspective. Interestingly, OHA added a new proposal in their rules in which a client administration area where there will be group administration sessions held will have to contain at least 25 square feet per person present at an administration session. So that includes clients and facilitators. So service centers, when they're planning out their floor plan, will have to take this into consideration and make sure that they have enough square footage in their administration area to accommodate however many clients they will be hosting in a group session. One, I think, positive change that OHA made was in the previous rules for group sessions, the OHA required that a client be able to request to be separated from the group session and go into a private session with their own facilitator. So in that case, a service center would have to have multiple backup facilitators on hand in case one or more clients wanted to leave a group session, which would be a bit of a nightmare, I think, for some service centers to have so many facilitators on hand who may not end up facilitating anything at the end of the day. So OHA removed that rule provision completely, and now clients must only be able to request individual support from a given facilitator during a group session, and a facilitator must make reasonable efforts to move any disruptive client to a separate area within that administration area, but there no longer needs to be backup facilitators for every single client at a group session. OHA is also proposing to increase the total number of clients who can undergo administration sessions at once at a service center. Previously, that number was 25 clients, and that OHA is proposing to increase that number to 100 clients who can attend administration sessions in one service center at once. And I think that that's going to be a good thing, especially for sort of these large retreat psilocybin service providers. And then Kaci touched on this a little bit, but this was sort of a pretty controversial rule when the rules first came out regarding these transportation plans. And these are the agreed upon plan at a preparation session between a facilitator and client for how a client will safely leave the service center upon completion of an administration session. So some of the issues were that the rule required that a transportation plan would not allow a client to operate a motor vehicle after the administration session, that a facilitator must make reasonable efforts to prevent clients from operating motor vehicles after administration sessions. And then most controversially, I think, the rule required that a facilitator contact law enforcement if a client fails to follow their transportation plan. So that was putting a lot of sort of onerous requirements on a facilitator to ensure that a client follows their transportation plan. And who knows what a reasonable effort to prevent a client from operating a motor vehicle is. You know, can you physically restrain them? And so there were a lot of issues there, I think. In the current draft of the rules, a lot of that is still intact. A client still cannot operate a motor vehicle after administration session according to the rules, and a facilitator still must make reasonable efforts to prevent a client from operating a vehicle. One change is OHA removed the requirement to contact law enforcement if a client fails to follow the transportation plan and may present a danger to themselves or others at the end of an administration session. And they replaced law enforcement with, quote, appropriate emergency services. So I suppose technically the new rule does not require a facilitator to contact law enforcement in the event that a client wants to leave a session and may present a danger to themselves or others because they're still under the effects of psilocybin. But, you know, I'm curious what other appropriate emergency services there are to prevent a client from potentially causing danger to themselves or others. So I'm not sure if that change in language really changes a facilitator's responsibilities. One interesting change to the transportation plan, though, is at the end of an administration session, there's this new rule where, quote, a facilitator shall require every client to sign a release document at the conclusion of the administration session. And that release document must state that the client agrees to end their administration session and follow the terms of their transportation plan. So at the very least, that limits some liability for facilitators when they choose to end an administration session, and in the event that the client actually ends up using a motor vehicle to leave the administration area. So those are the most notable changes, I think, to administration sessions. And I will throw it back to Kaci to talk about some facilitator issues.
Thanks, Alex. Okay, so I'll just quickly cover facilitator standard of care. These rules really haven't changed that much since the last round. So under the rules, facilitators have a duty to put clients' interests above their own and to use a standard of care that other reasonable facilitators would use under similar circumstances. And to figure out what other facilitators would do under similar circumstances, an obvious place to look is the OHA rules themselves, which govern what facilitators can and cannot do, and then also the content and information that facilitators will receive during their training programs. Standards of care are really something that will, evolve over time as the industry ages in Oregon. Facilitators also have to provide psilocybin services within the limits of their professional competence. That means facilitators should try to remain aware of the client's needs and assess whether they're the best fit or should refer the client to another facilitator. One potentially problematic rule, which is a holdover from the last round of rules, is a requirement that a facilitator not engage in a romantic relationship or sexual contact or intimacy with a client's partners, or the client's immediate family members for 1 year following the date the facilitator provides psilocybin services to the client. So this rule would prevent someone from being a facilitator for their romantic partners or spouses. It would also prevent one spouse or partner from providing services to their child if they share a child with their current spouse or partner. So, I think I understand why the OHA wants to protect against this sort of thing, but I think this rule needs to be, reconsidered for pre-existing relationships and some other scenarios. So next up, I'll just briefly discuss scope of practice. Scope of practice is defined in the OHA rules as practicing boundaries related to facilitation and avoiding the unlicensed practice of other disciplines, including but not limited to medicine or psychotherapy. So the rules say that a facilitator can't engage in any conduct that requires additional professional licensure. They can't exercise the privileges of any professional license that they hold in another field while they're providing psilocybin services. So facilitators need to be mindful of being non-directive, which means to take an approach of maintaining a consistent disposition while avoiding giving direct advice or directly interpreting a client's statements or behaviors. And if a client wants to engage their facilitator for more directive services, such as psychotherapy, they're just going to need to do so outside of psilocybin sessions. One new rule is that facilitator is prohibited from transferring, selling, or handling psilocybin products while they are facilitating, even if that facilitator is a licensed representative of a service center. The reasoning here is a little bit unclear, but I think it's probably likely included to prevent facilitators from trafficking while they're providing psilocybin services, which could be beneficial from a 280 tax perspective. So those are the rules. So far, no one has stepped up to say that professional liability insurance will be available for facilitators. That really remains to be seen. Facilitators and service centers are going to need to rely on general liability waivers to protect themselves against claims of ordinary negligence and breaches by facilitators of standards of care. Those releases should be part of the overall contract for the client, should be given to the client for review during the preparation session, ideally, in addition to the other documents that are required by the OHA that I discussed earlier. So that's it for me, and Dave's going to pick it up from here.
Yeah, thanks, Kaci. On the insurance issue, we spoke with a number of different brokers, and they've assured us that there will be underwriters, insurance companies who step up and provide general liability insurance, products liability insurance, directors and officers insurance, and things like that. But when I pressed them further about whether they would have professional services insurance, or otherwise known as errors and omissions insurance, the answer was not yet, and that came from multiple brokers. Sean and I were in Miami last week for this Wonderland Psychedelics conference. It was mostly pharmaceutical. There was a few mentions of Oregon, but mostly kind of the FDA biotech track. And I met a broker out there who was literally flying to London this week to talk to Lloyd's of London about professional services insurance for Oregon, among other things. So that broker seemed to really have their head wrapped around what was happening in Oregon more than the other brokers we spoke with. So if anyone has heard of anybody who's actually, I'm not saying we know everything, but if anyone's heard of any brokers who are actually going to offer professional services insurance, I'd like to hear about it. And if we hear of any, we'll circulate it around. But so far, I haven't heard of anybody, which means, and if nobody steps up, or if the prices are such that they're just completely cost prohibitive for people, then, like Kaci said, service centers and facilitators are going to have to rely on basically be uninsured in that respect, and rely on contracts and contractual waivers to protect themselves. Okay, yeah, John, I'm looking at John Dennis's comment in the box. John, let us know for sure if anybody comes through. And also, it would be great to if we had two companies, right? Because you have one company doing it, then they got an automatic monopoly, and there goes your bargaining power. Okay, so I was going to really quickly touch on microdosing. Alex and Kaci mentioned rules. Way back in January, we had I think our first webinar just dealt with the possibilities of microdosing. I think it's doable here. You have to mishmash all the rules together, the group sessions and the minimum duration of an hour, and the transportation plan seems a little wonky when you're talking about microdosing or low dosing. And there's an awful lot of paperwork. Kaci and I were just sort of making a list of all of the documents that you have to have for every client. And if anyone has purchased a house, you sit there with the title agent, the title agent and title company, and they just, your wrist gets tired from signing papers because they're just sign this, sign this, sign this. And so it may not be that bad, but there's going to be an awful lot of paperwork. And the first thought that went to my mind is service centers are really going to have their systems down and be very organized. And so to get everything right and to cross all the T's. So microdosing and low dosing, I guess it just remains to be seen how viable a business model that is, and if anyone is going to sort of go that route. And then I'll just mention 280 really quickly. I'm generally very pleased with the way the rules are so far. I have a couple of nitpicky comments still I'm gonna send into the OHA, but I think by and large, with respect to the sessions, with respect to the real property and the real estate, and the fact that that client administration sessions can be used when sessions are not taking place, they can be used for other purposes. There's no subleasing, but they're allowing you to sort of allow others to temporarily use the space. So I think there's a decent amount of flexibility to allow licensees to do their best to come up with structures to minimize the impact of 288. It's definitely something that has to be dealt with. Nobody's out of the woods, but it's encouraging, and I don't see anything that completely would unnecessarily screw it up for us. So kudos to the OHA for doing that. I don't know if they did it accidentally or intentionally, but so far, subject to a couple of nitpicky comments, I think it's about as best as we could do. So